Yeah, I think we can start. And we're now recording. Thank you. So thank you for attending to this webinar. We are anyways recording. We don't record the questions. So if you have any question, you could send the question to MB to my chat, for example. And if you have questions, or if you want to, or if you want to send to anyone else, I recommend you ask in a way it's a general question. I'm not allowed to answer questions about a particular case in public. And also the questions are not gonna be recorded. So if the question pop up while you are while I'm talking, you can write it to the chat or just wait until the end. So because as I said, we don't record questions for people to feel free to ask. So I'm talking here from the on-site Wolostic territory, Fredericton, New Brunswick at this moment. I'm Child Duarte, tenants advocate for the Coalition for Tenants' Rights. This webinar, it is in English. Next week, this coming week on Tuesday, is gonna be in French. I already did a series last year about the Residential Tenancy Act and the tenants' rights that is recorded and posted in the Facebook page of the MB Coalition for Tenants' Rights. If you're curious or have a question, you can see the recording and also the PowerPoints. If you are maybe want to share this through the Facebook page, feel free. That's why we don't record the questions. And this one is going to be about rent increase. The following week is going to be the same, but in French. And after, we are going to talk about termination of tenancy. These two subjects I'm talking about because it was too many changes in the last month after I did a series of the webinar. So it's to make the point what happened in between. So I'm going to start right now. So we're talking about the current regulation or for rent increase. Today, July 18, 2023. So the notice for rent increase. So it is important that the notice for rent increase, it is a notice. It is a document that the landlord have to give to the tenant. Just a text message saying, hey, I'm increasing your rent, or a call, or an email even, is not a notice of rent increase. That is really, really important, because if the landlord don't do the notice respecting the requirement for a notice, that rent increase is not valid. So a notice have to have the name of the tenant. When I put these numbers here, that means that is the number of the section in the Residential Tenancy Act of New Brunswick. So the notice have to have the name of the tenant, have to have the address of the premises, so where you live. Have to, if you live in an apartment, have to have the number of the apartment, have to have the amount of the increase, and when the increases take to effect. And that is really important. We are going to see during the presentation why and how that is important, and have to be dated. So have to have a date and signed by the landlord or an agent or representative of the landlord. So if it's a company, so it can be the representative of the landlord, the person, secretary, but it have to be signed. That is really important too. Well, I put choices in brackets because it is like the choice. So when a tenant receives a rent increase, a notice of rent increase, the tenant can elect between, so accepting the rent increase or taking it as a termination of the tenancy. So they can, that is, so the landlord doesn't have to give a termination. That is can be taken as a termination of the tenants if the tenancy of if the tenant doesn't agree with the rent increase. So when it's treated as a termination, in case of a fixed term tenancy, so something fixed, not year, not month, it has to be at least a month, so you have to live on a month. In case of a week, at least a week, on before the date immediately preceding the date of which the increase in rent is to take effect. So this increase has to be done. We're going to see, there are particular, for mobile home, if you live in a mobile home, if you are renting a mobile home, there are particular situations. So that choice, the notice has to be served during the 6-month period by serving the notice of termination, and the landlord have to give the tenant a month to live before any month within the 6 months. So there are the 6 months of termination. I know it's confused. That is why we are doing this webinar. There are the 6 months for the notice of the increase / termination, and the person can leave and have to be only 6 months. So a space of 6 months between each. So, and the person can leave the last day of that month. So what it does increase when the tenancy runs year per year, month to month, or week to week, the landlord shall not increase the rent. So there are only can increase, have to give the notice 6 months prior the increase. That means, for example, if the increase is going to be on July, the notice has to be given on January. If it's not, it's not a valid notice. Have to be a document separate from other notice. Other thing that is happening, it has to be separate, and the increase has to be reasonable. So I put in bold reasonable because it's really something to interpretation. And the website of the Residential Tenancy Tribunal, it says the market, but that is an interpretation. That is not exactly what the law says. The law says reasonable, so it's not necessarily the market. It has to be something charged for comparable units in the same geographic area. I know, and that is a problem, that the law is not clear about what means by geographical area. So that is up to discussion too. When? So, except when a landlord or tenant had agreed in writing otherwise. So that is when the tenant has to be really, really aware that don't agree to a rent increase. Don't sign it, don't say yes. Wait until you really agree to that. Wait until if you don't agree, if you feel that it's not right what is happening, you make a complaint. We're going to see how to make the complaint. Because if it's agreed, so if you say, oh, yes, if they send a text message, oh, you have a rent increase, and you say yes, or put that thumbs up, you agreed. So be careful, not agreeing things that after you called contest. So if you don't agree, if the tenant and the landlord don't agree about the rent increase, so it has to be, it cannot be the first year, the first 12 months. It cannot be, it has to be always every 12 months. So cannot, no, it doesn't have to be every 12 months, but it cannot be before the 12 months before, prior another rent increase. And we're gonna see when the tenants officer can spread a rent increase. So it's a little particular, that is why I have a slide particular for that. What happens with mobile homes? A landlord can increase a rent for mobile home inside if they provide 6-month written notice. We'll talk about that. And may increase. So there is not the 12 months. If you live in a mobile home, it's 6 months. It has to be a document separate, like always. And then for mobile homes, they are not talking about reasonable. They are not talking about geographical area. They are talking about the same percentage for each mobile site. So landlord cannot increase the rent for just one mobile home, because they have to increase the rent to the whole lot. That is really important. So if it's not like that, if it's not the same percentage for the mobile home park in the same district area, that means that increase is not valid. When to complain? Be really careful about that. So when you receive the rent increase, the notice, I suggest you complain. Even if there is a notice, if you see that, because you don't know if even you can interpret it, but it's better to be sure, of course, if you don't agree with the rent increase, that if you don't complain in 60 days after the receipt of the notice, you are accepting the rent increase. And even if not respecting the law, you are accepting it. It's gonna take as an agreement. So you have 60 days to do it. I suggest as soon as you can, you complain. When to complain when you live on a mobile home. So see that for if you live in a mobile home, you have only 15 days. You have less time. So it's not 60 days, it's 15 days. What is being examined? So to complain, they are gonna see if the form of the notice is according with the law, if it was served 6 months before the rent increase, if the landlord increase is comparable with the unit in the same building by the same percentage, the geographical area, now is talking about reasonable, depending if a mobile home or not a mobile home. If you live in a fixed term lease, so a fixed term lease is different than year per year, month per month, more week per week, is fixed term. So the landlord have to provide a written notice 3 months before. You see, it's different. It's not 6 months, it's 3 months. The landlord may increase the rent only if this choice has been selected. So in the standard form of lease, when you do a fixed term, there is a section. If that section was selected, and you sign it, you are allowing to do a rent increase. If not, they cannot do a rent increase. What is being examined if you live in a mobile home? In a mobile home, the residential, but we're gonna see if the notice was made in a separate document, and if the landlord is increasing the rent for each mobile home in each site by the same percentage. That is what the officer is gonna see. So we're talking about the retaliation. It's not allowed to do a rent increase by retaliation. That means if you are complaining, for example, about the landlord not fulfilling the obligations because you asked it for many times that there is humidity, that there is rodents in your apartment, and after that they don't do it, that you did a complaint to the residential tenancy tribunal, and the landlord said, oh, now I'm doing a rent increase because I want you abandon the apartment, to say, oh, it's terminated this contract. So when you feel, when you see that a rent increase is in retaliation because you did a complaint, and now I'm thinking, if a complaint anywhere, not only the residential tenancy tribunal. For example, if you are a victim of discrimination because because you are part of a minority, because you feel like the landlord is discriminating you because sexual orientation, because many situations, and you do a complaint to the Human Rights Commission, and the landlord say, oh, now I'm gonna increase your rent, so you have to leave. That is a retaliation too. So when you receive a notice of increase and you see that is a retaliation because you complain, so that you have that notice of increase is not valid, but you have to justify, and you have only 15 days. If you are arguing, make attention here, if you are arguing because the rent increase is retaliation, you don't have any more 60 days. You have 15 days. So that is why I'm telling you, even if the law say that you have 60 days, depending on the case, and because we are never sure what is happening, it's better to do as soon as possible. So in case you are arguing discrimination, you are arguing that is retaliation, you only have 15 days. You cannot lose that possibility of the complaint because you are outside of the limit. The landlord have to justify that is not retaliation. So then is when we are talking about evidence, and it is important to have evidence. What can be an evidence? An evidence can be a text message, can be, if you are using videos, with videos, it's important to have to provide that with an USB, for example, not too long, maybe taking pictures also, and being clarifying why and where is the discrimination in the minute this and the minute where. It's better to be clear, not just sending things. You have chances to be more successful if you classify your evidence and you show why you are putting that evidence on your complaint, in your complaint. So a landlord and a tenant within 7 days of being notified of the decision made by the residential, let's say they decide, oh no, it's not retaliation. So you have 7 days to ask the chief of the residential tenancy tribunal to reconsider. So it's not an appeal itself, but it works like that. And the chief of the residential tenancy tribunal can affirm or reverse the decision. What happens if you still don't agree with that decision? Unfortunately, even if we have a name of a tribunal, it's not a tribunal. I think they already changed it again. But it's not, we don't have really something like, so you have to go to court. We're gonna see later that there is the UMB Legal Clinic. They can help you with going to court, and even they can accompany you to this complaint, depending on the case. What happens if the officer confirms the notice? So if the residential tenancy officer confirms the notice, they want to confirm the date set out in the notice as the date of increase in rent is effective. They could change the date of increase. So they could say, oh no, it's not, I decided it's not this, it's gonna be later. Or unfortunately, they can decide it's gonna be earlier, it's allowed. If they meet the criteria prescribed by regulation, so we're gonna see that it can be a spread if it's above the CPI of the year. So how they distribute the rent? This is really confusing, but that is how it works now. And unfortunately, there is nothing that force the officer to spread the rent increase. It's up to them. So let's say if the rent increase go above the consumer price index, the CPI, they are gonna take in account the CPI of the December of the previous year. So for this year, it's gonna be December 2022. If it's above, if it's bigger, the CPI is gonna be spread in 2 years. If it's the double, it's gonna be spread in 3 years. So that means you are staying in that apartment for 3 years. Many things can happen in between, but that is what the law says. Well, now we are talking about how to file a complaint. So as I said, by default, file a complaint because you have so little time to see and add evidence. So you can submit a written request to a residential tenancy officer. Well, I suggest 30 days after receiving a notice of increase, but as I said, it's better before 15 days if you are in retaliation. It's better 15. You can apply online, or you can bring it to Service New Brunswick. So I suggest in renting in New Brunswick, you can see the website and you can go through the forms. What I feel is really important to say that calling to Service New Brunswick is not making a complaint. Many people call, they say something, no, make the complaint. Only making a complaint, you have a complaint. Just calling is not a complaint. As I said, I was going to announce the UMB Legal Clinic. It is for the province, not only this is the address when they are operating, but in Fredericton, but you can call, you can write, and they are province-wide. They are helping people with tenants rights across the province. I think they are going when during the year, I don't know, in summer now, if they are continue going to St. John, for example. But I work closely with the legal clinic, and I know that they are also doing some virtual clinics. So I suggest if you feel like it's too much, all the evidence, and I suggest you contact the UMB Legal Clinic. So that's it. We're gonna stop the recording. And